knowledgeable words on patent.
Very good afternoon, everyone. So I feel rather very humbled being called as a speaker among such dignitaries and such high-level academicians, and me being per se last year's graduate, and recently I've joined this practice of law, and I have been into IP prosecution from past 4 years, and for the past 1 year I have been into litigation. So whatever limited experience I do have, I'll share it with you all, and let's see how I can mention about IP enforcement and litigation in India before you all. So let's first start about IP enforcement. What exactly is meant by enforcement? Whenever you get a statutory right, that means a right which is encompassed under any statute. Statute is any act. For example, the Trademarks Act, the Design Act, the Copyright Act, and so on and so forth. So these acts encompass registration. For example, Section 18 of the Trademarks Act says that your trademark, registration of a certain trademark. So once you get your trademark registered, it's then the time for enforcement of that trademark. Similarly, it stands for the patent, for the copyright, and for the designs as well. So enforcement starts after your registration process, which is called, the registration process is called the prosecution. So let's understand firstly the difference between prosecution and litigation. So prosecution is the area where you apply for an IP, for say trademark, for say patent, which Dr. Singh very precisely explained. When you apply for an IP and then you get those IPs registered, that very area is known as prosecution area of the IP. And the whole process includes the filing and then the examination replies and then the hearing of that trademark and then lastly the decision of that. I'll give you an overview. So first you apply for a trademark. This is the prosecution side. I'm not talking about litigation per se. When you apply for a trademark, you get an examination report at the very beginning, wherein certain trademarks are cited, which they say that your trademark is similar to these and these marks, so therefore it ought to be not to be registered under section either 9 or section 11. So it's what section 9 and 11 say. That section 9 says that whether, as very well explained by my previous speaker, that there are certain generic trademarks. For example, as he said, apple for an apple. Like if you're selling apples, you cannot have a trademark called apple. Like if you're selling, say, a laptop, you cannot have a trademark named laptop. So therefore, under section 9, all these things, the generic trademarks are included, which cannot be then registered. Similarly, in section 11, so these are basically the two major sections wherein the examination report comes. So section 11 says that if your trademark is deceptively similar to another trademark, so it cannot be registered. For example, from my own experience, there was just one example. I've handled around hundreds of trademark examinations. So there was a trademark called Tufan and another trademark called SNJ Tufan. So there's no per se differentiation between these two trademarks. Just the addition of the prefix SNJ. Would that make that trademark different? No. So the very well laid down law for this is, if you add either a prefix or suffix to a trademark, it cannot be registered if the major portion of that trademark has been copied. In this case, the major portion was the mark Tufan, and Tufan was for products agarbattis in the specified class 3, I believe. So these are and additionally, classes are being defined for trademarks. For classes from classes 1 to 34, these are the trademarks for goods, and from classes 35 to 45, these are the trademarks for services. And every goods and services are then, every trademark is then applied as per those goods and services in that particular class. And then one also legal principle comes, which was laid down in the case of Nandini versus Nandini trademark case. When you will perceive these marks, Nandini and then the other mark Nandini, you will feel no, there's no differentiation between these two marks. Just the addition of the word H in the Nandini, and there is no word H in the Nandini mark. But still, these marks were held to be not similar because they were applied in different classes. The different classes means one was applied for dairy products and other one was for oil products. So therefore, the differentiation was claimed, and then these marks were separately used and then registered. So this is how the trademark prosecution area works. And then the subsequent hearing comes when you give your own submissions before the registrar that no, see, my trademark is this, it is used for these and these goods, and therefore it is different. So then if the registrar believes your contentions, your trademark is then registered. So once now it is registered, this is the stage of enforcing it. Now, for example, you register your trademark, say ABC, and you find someone using that trademark in a deceptively similar manner, and you then, the first step what you will take is then so yeah, as I was saying, after you gain your IP portfolio, you make your IP portfolio a rock solid one, then you come to the enforcement area. As I was saying, you apply, you got your trademark, say ABC, registered for a certain thing, and then you find out that there's a person who is using your trademark which has been registered by you. The first step that you will take is issue a cease and desist notice. A cease and desist notice is wherein you briefly outline your case stating that, see, this is my trademark, you cannot use this trademark, I have these and these registrations, so therefore stop using. Cease and desist, what it literally means is cease from using my trademark or your deceptively similar trademark to mine trademark, and desist from further using that trademark. So this is basically the cease and desist notice. Other than that, usually damages are also mentioned in that notice. You give me, for example, 50,000 rupees since you have used this and this trademark for say 3 months, and therefore you are liable to give me damages for these and these of using this deceptively similar trademark. So the next stage comes. So this legal notice has its own pros and cons. The pros is specifically that since you have made it clear that you are enforcing your right over that trademark, so therefore he should not use it. So that is similarly the basic pros of a legal notice. But there is I would say a gray area issued attached with it. From the defendant side, what would the defendant do? The person who is receiving the legal notice, he will put up a caveat in the court saying that I have put up caveat under section 148A of CPC saying that, see, I have an apprehension that this person shall file a case against me, so therefore I'm putting this caveat, so no interim injunction or no order may be passed before hearing me. So that is a bit of a lacuna in, I would say a lacuna in sending a legal notice if you want to gain an interim injunction. So even otherwise, there are some cases wherein when you give a legal notice, at that very moment that matter can be settled. So in one of our cases, so we were representing Perfetti Van Mill. It is a confectionery company. So it had a trademark called Happy Dent, you must know. And we then sent a legal notice to one distributor in Bihar who then said that yes, we'll comply with your everything and we'll change our logo, the Happy Dent logo. And so therefore the matter got settled with that very legal notice only. But since there are certain people who also assert their rights over a certain trademark, saying that no, since I am a prior user of this trademark, so I'll be using that trademark per se, and no, you do not have any right over that trademark. So then the litigation area starts. So the first thing the defendant, the receiver of the legal notice would do is put up a caveat saying that no injunction would be granted against me. So this may go against the plaintiff for gaining a this prior injunction for getting for for making the suit in his favor. Usually the usually injunctions are sought at the very first stage without even notifying the defendant. So these are the injunctions which are enunciated under Order 39 Rule 1 and 2 of the CPC, wherein it is specifically mentioned that if there is an urgent relief that you want to claim out of a certain act of a certain defendant, you will put up a claim, you will put up a suit, and then you will also apply for an interim injunction under Order 39 Rule 1 and 2, saying that see, he has been using this trademark from say let's say 2 to 3 months, and now since he has been infringing my rights over this trademark, so I have a right of getting an urgent interim relief. So what the court would say is, yes, there is a need of urgent interim relief. So so they'll grant an ex parte injunction. Ex parte is without having the next party with you, the defendant party with you. The court will then grant an ex parte injunction saying that till the next date of hearing or till this application of 39(1) and 2 has been decided, the defendant shall stand restrained from using this trademark or using any other deceptively similar trademark to this trademark. So this is the first step of any IP matter, wherein you go to the court either by sending a legal notice or without sending a legal notice, and then apply for an interim injunction. So this is how the first step for any infringement suit goes on. So these are the type of actions which you can claim in a lawsuit, particularly in an IP suit: invalidity, infringement, and passing off. Invalidity has its two aspects of litigation. Invalidity of a trademark, let's say, or of a patent can either be filed in the registry itself or in the court itself. So I would cover the areas wherein it is filed in the court, since this is a litigation mandate. So invalidity of a trademark, let's say it is covered under section 4757 and 125 of the Trademarks Act. 47, as explained by Dr. Singh, is on the grounds of non-use. If the trademark person, if the holder of a trademark, if the registrant of a trademark is not using a certain trademark from 5 years and 3 months prior to his application, so his trademark is liable to be cancelled. His registration is liable to be cancelled. Similarly, under the section 57, it is given that if the trademark is wrongly registered. So how wrongly registered is then defined, that if it is deceptively similar to any other trademark, if it is against the law of passing off, then it needs to be cancelled. Its registration needs to be cancelled. And then, yes, definitely the infringement and passing off. So first, let's understand the difference between infringement and passing off. Again, I would give an example of trademark, since the concept of passing off comes from the concept of trade dress, which again arises from the concept of trademarks. So infringement and passing off are two separate actions, usually combined in many matters, wherein a trademark is already registered, or and the other person is also using the whole packaging which is similar to that trademark. I'll give an example to make it clear. Suppose there's this Apple laptop. It is being sold by another infringer with having the same icon, the Apple icon, and having the same packaging as well. There's a certain packaging wherein this MacBook would come, and in the exactly similar packaging, the other person is also selling these goods. That is the copying of a trade dress. Trade dress is something more than a registered trademark. It includes the packaging of the product as well. So usually these actions are combined whenever you file a suit for infringement and passing off. So the other thing is, if your IP is not registered, then the case of passing off comes. Then you cannot claim infringement, just the passing off. For example, again, suppose this laptop's IP is not being registered, its trademark Apple is not registered. So you go to the court, you say that, see, I might not have a registered trademark, but I want to exercise my rights through a common law remedy called a passing off remedy. So passing off is not a statutory remedy per se, it is a common law remedy, and under section 11, although it is given under section 11 subsection 3, it is also given, although given that trademark which is against the laws of passing off cannot be registered, so therefore very slight statutory provision is there, but per se when this passing off action is being applied on, there is no statutory provisions being mentioned there. And then one other aspect is kia-timid actions. Kia-timid actions basically mean that you have an apprehension that his trademark or his IP would be infringing to your IP and that it would damage your goodwill. So kia-timid actions are based upon apprehension. Apprehension कि मुझे डर लग रहा है कि ये मेरी IP use कर लेगा. So on that very basis, kia-timid actions are put before the court, and kia-timid actions can also be put up for invalidity. So say you have a apprehension that his registration of a trademark might infringe my trademark, since, for example, now trademarks are applied on two bases, either on a proposed to be used basis or on a future use basis, or on a prior use basis. Proposed to be uses, you apply for a trademark, you say that, see, I want to apply for this trademark, and I'll start using this trademark from a certain later point of time, and so therefore let my trademark be registered at this time on a proposed to be used basis. The other thing is you apply a trademark, say that by saying that no, my trademark is being used since 1983, for example, and therefore I am giving this affidavit on that behalf and giving the documents on that behalf, saying that, see, I have invoices since 83, so therefore my mark be registered from a priority claim of 1983. These are the two types of application which are in the trademark. So once the trademark is registered to be used basis and it has not been used since, and it has not been used even for a sale or on a first point of time, it has not been used. So therefore even then a kia-timid action can also be taken against the invalidity of that particular trademark by saying that I have an apprehension that once this trademark is being used, so it would cause damage to my goodwill. So therefore these are the kia-timid actions, and I hope infringement, the difference between infringement and passing off is clear. So there's this concept of extended passing off, which I added just now in my presentation. A doubt came earlier to Dr. Singh that saying that 20 years patent, there's a threshold of 20 years for the patents. So what happens if anyone infringes my patent after my limitation is over? So a very clear answer for that is no, you do not have any statutory right for it. But Delhi High Court in certain cases has introduced a concept of extended passing off. What extended passing off means that if you are able to prove that there is a similarity for our case, which I represented a firm, so that was a chemical patent case, it was pharmaceutical, I must say. So what happened in that case was, that was a case of extended passing off. Our patent was about to expire in about 1 or 2 months, but since we found out that certain other entities also using our patent without authorization, we filed a case for infringement for the particular 1 or 2 months, and then after infringement, a concept of extended passing off was laid down, wherein if you are able to prove that there is a misrepresentation with respect to the similarity of the product, say, what exactly has been held in that case was the biosimilarity of those chemical products was taken to be similar, and that's how an extended passing of case was made. There was a misrepresentation due to the biosimilarity of those products. Secondly, there was damage to the goodwill of the original patent holder. And thirdly, uh, uh, there was obviously the goodwill was being hampered due to such activities. So therefore, an extended passing of case was made. Although now what usually happens is, if there is no law and you have filed a certain application or filed a suit, so what defendant would next do is file an application under Order 7 Rule 11 saying that this plaint needs to be rejected on the very first go, since there is no law which would recommend this suit. So the plaint has to go, the suit must go under Order 7 Rule 11. So what defendant did to us was they filed this application 711 saying that, see, there is no concept of extended passing off in the law, but so therefore their suit must go. But then we represented by saying that no, there is an extended passing off which has been followed since a case which was decided in the court of UK, wherein the similar stand was taken that the concept of extended passing off can be followed. It is a common law principle. And thereafter, we showed some judgments to the court saying that, see, Delhi High Court has also been following this concept of extended passing off. So therefore, this case is very much maintainable for decision. Now, there might be a case that the judge decides against the plaintiff saying that no, for extended passing off, there has to be certain amount of very rock solid documentary evidence, and that is really hard to prove in the court in case of extended passing off. But there is a remedy even after 20 years, even after the expiry of the patent after 20 years. So this was just for adding that thing. So what exactly can you claim in your suit? So these are, first of all, the injunctions, the damages, the invalidation of statutory right. So it is most probably similar to my previous slide, saying that in a suit what I can actually claim therein. So injunctions there are certain types of injunctions called Mareva injunction, Anton Pillar injunction, Dynamic injunction, and Ashok Kumar injunction. I'll explain these classes later on, but as of now, let's get the umbrella classes of these injunctions. So first are temporary or interlocutory injunctions, second are mandatory, and third are permanent sort of injunctions. So temporary injunction is when a court finds out on a prima facie level that no, plaintiff has a case in his favor and balance of convenience lies in his favor. So therefore, he is liable for a certain temporary injunction for restricting the defendant for a certain amount of time or till the next date of hearing from using the IP which has been claimed by the plaintiff. So those are the temporary or interlocutory injunctions. Then secondly, the mandatory injunction, wherein the court says the defendant to do a certain mandatory activity to not infringe upon the rights of the plaintiff. For example, saying that you will not sell your goods in the particular area of let's say Raebareli. So that would be a mandatory as well as a temporary injunction, since since the trademark is, of course, it cannot be a case, just a hypothetical example. So just to let know what exactly are these injunctions. And then lastly, the permanent injunction. When the suit is finally decreed and it has been held that, see, you are infringing the IP of the other person, so therefore you are now permanently injuncted till the lifetime of the IP to not use this IP for your future mandates, for your future commercial mandates. So those are permanent injunctions. Then coming on to damages. So damages can be claimed. Allow me. So yeah, damages can be claimed that are of four types: the compensation, the punitive damages, actual damages, and statutory damages. So the meaning of all these are very near to each other, just leaving the punitive damages as those are the extra damages which are added by the court. So compensation is usually with respect to trademarks and copyrights, wherein if an IP is infringed by the other person, compensation is given to the aggrieved party. So those are merely the compensation. It is the easiest form of damages. And then there are the punitive damages. So courts in India have shown a trend toward awarding punitive damages in addition to the actual damages to act as deterrent to the infringers. So the deterrent theory is a very accomplished theory in law, wherein it has been held that in order to make the other infringers or the other person who might be infringing some other person's IP, in order to create a deterrent effect on that person, punitive damages are awarded. For example, if compensation of say 10,000 is awarded to me, an additional 10,000 would also be awarded to me as a punitive damage, which would say that, see, a deterrent effect has to be made for other infringer or for other people who might infringe some other person's IP. So therefore, these punitive damages are given for creating a deterrent effect. And then thereafter we have actual damages. Actual damages were celebrated in the main Philips case, the Philips versus Amaze Store case, wherein damages amounting to 3.85 crores were given to the plaintiff. Since it was held that the defendants were infringing their IP, so the actual amount of damages, which were calculated on the basis of rendition of accounts. Now, what rendition of accounts means that I have a certain IP, and I catch hold of any one of you using that particular IP, and since it has been used by you from say, let's say 5 years, so whatever account of profits that you have earned from those from that infringing use, that would be awarded to me as an actual damage. Now let that be a 4 crore, 5 crore profit, all of that would be awarded to me. So that is actual damage with respect to rendition of accounts. And then lastly, statutory damages, which are actually mentioned in the statute, saying that there's a fine of say 10,000 rupees for infringing activities and all. So those are statutory damages. And then obviously the invalidation of the statutory right, as earlier told, and invalidation or even revocation or cancellation petition of a certain IP, say patent, copyright or trademark, can be filed in the High Court having the original jurisdiction. So therefore, if you pass in that case saying that, see, my IP, my prior usage rights has been infringed by a registration of a certain IP, so therefore it is liable to be cancelled. So then invalidation of statutory rights comes into place by saying that you may have a registered IP, but this other person who is the plaintiff has a prior usage right to that IP, so therefore your registration needs to be cancelled. So that comes under invalidation of the statutory right. The right which he has gained after registering their IP, it becomes invalidated after this one of the claim of invalidity. So yeah, now we'll come to injunctions. As I previously mentioned that there are 3: temporary, mandatory and permanent. There are other classes of injunctions which we can have while putting up a case for an IP infringement. Those orders are as follows: Mareva injunction, Anton Pillar injunction, Dynamic injunction and Ashok Kumar or John Doe injunction. So what exactly are these? Let's start with Mareva injunction. So it was, this doctrine of Mareva injunction was initialed in the case of Mareva Compania Naveria SA versus International Bulk Carriers. Now this is commonly known as the freezing order or the stay order. It is a legal remedy that is frequently employed in instances of fraudulent activities or asset misappropriation. As I said, this is also a type of temporary injunction. You go to the court saying that, see, he's infringing my IP, so therefore a Mareva injunction would be passed in favor of the plaintiff, saying that now defendant is not allowed to use that particular IP or a deceptively similar IP to that. So that is basically the Mareva injunction. So, and thereafter we have ant and pillar orders. Ant and pillar orders are usually when you go to a court, when you file an IP suit, you also file an application under Order 26, Rule 9, stating that you need a local commissioner from the court to assess the extent of infringing articles in the defendant's premises. For example, I go to the court, I apply for infringement of IP, and I apply for the other injunction, and one of the injunction being ant and pillar order. So what court does is, now court particularly cannot go to every defendant's house and say that, see, you are using this brand, you are using this patent, which is infringing of the plaintiff's patent. So therefore, court gives an order for ant and pillar saying that an LC would be given to you, a local commissioner, which is an extended arm of the court, which will go to the premises of the defendant and which will then make an inventory list wherein every good that is deceptively similar to the plaintiff's trademark or any IP per se, an inventory list would be made, and that those goods would be then further released on a term called Superdarinama. Superdarinama is that particular inventory list which is given to the person, to the defendant who is present at those premises, where the infringement is being carried on. So that inventory list is then signed by the defendant by saying that I will bring these goods to the court as and when it is required by the court or as and when it is called by the court. So therefore this extended arm of the court comes in the form of ant and pillar order, and usually these people who then go to these infringing premises are called local commissioners. And then we have dynamic injunctions. So dynamic injunctions are very prevalent in Delhi High Court. Usually Justice Pratibha Singh, if you would have heard, is known for giving such dynamic injunctions. So let's say there is a website which is using your trademark. You have a certain trademark, say you have a trademark of Puma. So a person makes a website, a rogue website for example, and say uses your Puma trademark in that very website. So in order to remove that website from all the hosts of the web server, these dynamic injunctions are given to remove all the rogue websites from a server. So basically, then again, dynamic injunction is also for the copyright usage or artistic work usage or the trademark usage, and not for the patent usage per se, just for trademark and copyright. And lastly is John Doe or Ashok Kumar orders. John Doe is basically an English doctrine, and Ashok Kumar is a rendition of that English doctrine into Indian judiciary. John Doe is a name which is given to a defendant which is not known to the plaintiff. For example, again, you receive a certain packaging of a trademark, of a certain packaging of certain goods having your trademark, but you cannot identify the source from where it has come. Some other person, your good friend has told you that, see, there is a certain trademark which has been used in this packaging, but I cannot locate the manufacturer of this trademark. You will go to the court, you will say that I have rights on this trademarks, and certain person which I don't know is using such trademark or any IP for that matter. So the court will then, what the plaintiff would do is mention the defendant's name as either John Doe or Ashok Kumar. In usually the English doctrine, the name John Doe is very regularly used, so therefore the injunction is named as John Doe. And the name Ashok Kumar, which is very prevalent in India, is used as the John Doe order or the Ashok Kumar order. The court would say, the defendant, even though unknown, or if you find it later on, I am giving a Ashok Kumar order or a John Doe order saying that any person will not use trademarks or a trade dress or any IP for which the plaintiff has rights, and therefore even that Ashok Kumar is then, that XYZ person is then counted under that order. So if you at a certain point of time find out, yeah, this packaging belonged to a certain person in say Kerala, So that person in Kerala would also be bounded by Delhi High Court's order under the John Doe or Ashok Kumar orders. So that is basically it. And then compensations we have covered. So now what are the criminal remedies in IP? So criminal remedies in IP, basically the statute mentions the criminal remedies only in Trademarks and Copyright Act. There is no mentioning in the Patent Act per se of the criminal remedies. The Trademarks Act under section 105, 103, 104, 115 accounts for the criminal remedies under the trademarks, which accounts that if the trademark has been used or has been registered under a wrong premise or saying that no, this is my trademark, so there's a criminal remedy against it. You can actually file an FIR if your trademark is being registered, is being infringed by some other person, and the police will have to take cognizance of that report. Similarly, under section 63 of the Copyright Act, statutory right is given to the to a IP holder, to a copyright registrant, saying that I have a copyright registration, and if you find any person who is infringing that copyright, you can always file an FIR, file a complaint before the police, which then turns into an FIR. Since under section 63 the offense is cognizable and non-bailable offense, so therefore, and then this complaint is then turned to an FIR, and the case then proceeds accordingly according to the criminal remedies as mentioned in Copyright Act and then under the Criminal Procedural Code. So these are the criminal remedies as available in the Copyright and Trademark Act. There is no criminal remedy which is mentioned under the Patents Act and not even under the Designs Act. So drafting of a suit, when you apply to the court saying that my mark has been infringed or my IP has been infringed, what all things you should include in that suit, in that plaint of yours, which would make the court believe you in giving you an interim injunction. You will give your introduction as a plaintiff. What are you? For example, saying that I am RGIPT, I have these and these trademarks, I have this and this reputation from last 10 to 15 years, I have invested this and this amount in my trademark, so therefore I have invested heavily in this trademark, I have statutory rights, I have registration of this trademark under the name of RGIPT, so therefore my rights under this trademark are substantiated in these 1 to 10 paras stating that I am the plaintiff and I have rights, I have goodwill, I have invested so much in that IP. Then you will give introduction of the defendant and how you found out about the defendant. You will say that there is a certain college which is near to the premises of Rai Bareli, for example, saying that it is also using the trademark RGIPT and it has been using it since so and so amount of time, and he has copied particularly from my trademark since I have been offering services to the children, to the students, of course, of engineering and whatever the courses we have. So you will define the activities of the defendant and then and since when he has been using. So now a gray area comes in here. Now if you write in your plaint that no, I know he has been using this trademark since past 2 years, so the court at the prima facie level will not give you any injunction. Why? Since for the 2 years you have lost, not exactly lost, but you have been sitting on your rights. So that is an action which can be against the doctrine of delay and acquiescence. So delay is when you go to the court after a substantial amount of time and then say that, see, he is infringing my mark. So the court would firstly question you that where were you at the very first instance? You got to know about usage of this trademark in the year, say, 2022, and now you are bringing your claim in 2024. What took you so long? And if you do not have any reasonable answer to that, a temporary injunction might not be given to you, and then the court will proceed for the evidence stage and the other stages of the suit. So that is how drafting of the suit should be, and after defining the defendant, you will then go to the cause of action. The cause of action is what all things, what the defendant has done, which has summed up to this infringement or passing of suit. And then lastly, your prayer would come, wherein you will be demanding the damages, as I said, the actual or punitive damages, wherein you will be demanding invalidating the defendant's registration if they have any, and then you will also be demanding the costs of the litigation. So these are the prayers which are usually made in infringement and passing of suit before the court. And then interfere of section 12A of Commercial Courts Act. Now section 12A, what does it say? 12A says that there should be a pre-litigation mediation before applying for any infringement action. So this, however, is under the provision that, or under a pretext that this that there is no urgent interim relief. So if you are, as I said, an application for interim injunction, which is covered under Order 39 Rule 1 and 2, it becomes mandatory in nature to circumvent this section 12A of the Commercial Court Act. If you go without that application of 39 1 and 2, saying that I don't want an interim relief, then the court would send you to mediation. In a way, it can be good for you that you can sit with the other party and then decide the merits as to how and when this IP should be used. Otherwise, if you are a plaintiff side, you will always want an interim injunction in your favor on the very first date. So therefore, to circumvent this section 12A of the Commercial Courts Act, what usually lawyers do is they file an application for 39 1 and 2 saying that this is an urgent case and therefore I want an urgent interim relief, and thus there is no scope of mediation under 12A that can be followed. Then lastly, the jurisdiction analysis of the IP suits. This is a very major point in IP suits. Now let's say the plaintiff is from Gujarat, the defendant as well is from Gujarat, but the plaintiff wants to file his case in Delhi. What should he do? Now, usually people do not file these IP suits outside Delhi, because in Delhi there is a scope for getting an interim injunction and there's a practice of getting interim injunctions rather more than the other courts. So therefore, a party in Gujarat, let's say, files in Delhi. So they'll have to sufficiently give reasons as to why the suit has been filed in Delhi. So what would the lawyers do? They'll say that, see, his trademark is being sold, the goods under the trademark, under the infringing trademark are being sold under Amazon, Flipkart and every other this e-commerce shopping website, and therefore from that website you can always get the infringing goods delivered in Delhi. So therefore there is a certain cause of action which is also being encompassed in Delhi. So therefore, when a certain cause of action has been believed to be or put up to be happening in the jurisdiction of Delhi, under section 20 of the Code of Civil Procedure, you can always file your case in Delhi. So therefore, this jurisdiction analysis is very important in the IP cases. In one of our cases, what happened was both of the parties, as I said, were from Gujarat, and they said that we were representing the defendants there. So they said that since our products are also listed in India Mart, so therefore the jurisdiction of Delhi is very much liable, since the products can always be bought from India Mart in the jurisdiction of Delhi. What we said was, no, this is not the case. The website, and what the law says as well, the website has to be an interactive website. So the India Mart website, if you have gone through, usually you put your query there, and then it is on the plaintiff to whether deliver to you in Delhi or whatever place. It is on the obviously the person who is holding the goods to deliver, and you can only put up an inquiry there. So therefore, it is not an interactive website per se. What would interactive website would mean is an Amazon or Flipkart website, wherein you can easily check by entering the PIN code there. Let's say, for example, in Delhi, a PIN code is 110017. You put up that PIN code there in Amazon, you will get that, yes, this product is deliverable in this location. So therefore, in Delhi, the jurisdiction of that very particular IP suit is made, so therefore you can apply for your IP case in Delhi. So that is why the jurisdiction analysis is very important in these cases. So this is a lifeline of an IP suit, how it moves on. So firstly, when you apply for a suit, when you put up a suit before the before any court, for example, the pleadings are done. What are pleadings now? The plaint, the initial plaint that you submit before the court, which is your substrata of your case that is included in the plaint. You give up your plaint, and then thereafter, since this is included under Commercial Courts Act, 120 days at the outer limit are given to the defendant to put up their written statement, which is popularly known as Jawab Dawa, or even the counterclaim in some cases. So 120 days at the threshold are given. After the 120th day, no written statement is entertained from the defendant's side, and the matter may then proceed ex parte. So once the plaint has been submitted, once the WS, the written statement has been submitted, and any other reply to the interim applications has been submitted, the stage of completion of pleadings arrives. So then the joint registrar would then put up the matter before court, saying that pleadings have been completed, the plaint has been filed, written statement, all the replies have been filed. So now the matter can proceed to the next stage. So the next stage comes is decision of the injunction applications. So as I said, Order 39 1 and 2, which is the most important application in IP suits, you put up this injunction application before the court saying that he is infringing my IP rights, so on and so forth, the whole story of your case, and then the court will then decide whether to give you an injunction, a temporary injunction at this stage, saying that till the last date of hearing of this suit or the last date of arguments, this injunction would follow or not. So then firstly this injunction, this application under 39 1 and 2 is decided. So once this is decided either in the favor of plaintiff or in the favor of defendant, only then the suit moves to the evidence stage. Now evidence stage is wherein the plaintiff, a witness from the main witness from the plaintiff side, even one witness, two witness, three witness, whatever the number of witness would be there, they will file an evidence affidavit stating all the grounds which are taken in the plaint, stating all the documents which are given in support of the plaint. So that would be the evidence affidavit. So that affidavit would be binding upon the witness, and only on the basis of that evidence affidavit, then the witness is cross-examined. Similarly, it stands for the defendant. Whatever witnesses the defendant is putting forth, every defendant would give an evidence affidavit stating his grounds and his documents which are being relied upon. So therefore, once these evidence affidavits are filed, a joint document schedule is filed stating whatever documents are admitted or denied by either of the parties. Let's say plaintiff filed a design registration certificate, his own design registration certificate. Defendant would come and say that, see, this is a copy of the design certificate, I would not allow it, so I'm denying this particular document. Similarly, every such document is then admitted or denied via joint document schedule, which is filed in the court. So when the evidence affidavit from both the sides and this joint document schedule is filed in the court, the proceedings then move to the examination of the witnesses. Chief examination is basically saying that मैं जो भी बोलूँगा सच के सिवा कुछ नहीं बोलूँगा. That is the chief examination, and then the whole documents are being laid and then exhibited and marked. So those are the intricacies of law that you might not want to go in. And the cross-examination. Now, a question would arise is, what is the need of a cross-examination in an IP suit? This is not a murder trial that a witness has to be cross-examined. But cross-examination has played a really vital role in some of our cases as well, wherein the witness was asked about questions like prior publication of their IP and even questions on the jurisdiction basis. What happens is, in one of our cross-examination, I was cross-examining other witness. I said that, is your design which you have applied, has it been priorly published anywhere? He said no. Then I asked him whether this design of yours, before being applied, was it given to any other people for CAD drawings? If you know what CAD drawings are, they're usually architectural drawings or drawings which are usually transferred from pen and paper to in a tangible, in a computerized form. So was this design of yours which was applied, was it given to any third party companies for their CAD drawings? He said yes. So then I said, did you had any business meetings before applying this design as to gain a market survey? He said yes, there were the market surveys. So and then I asked him whether this design which you have applied was exposed to the market survey. He said that yes. So therefore it was proved that his own application was priorly published, since it was given to a third party software company, third party CAD software company, and even otherwise it was also produced in a certain market survey to the public. So therefore his design application got cancelled on that very basis, that since his design has been priorly published, so therefore his design needs to be invalidated or cancelled. So that is why cross examination is really important in IP cases. One of other cases as well, cross examination played an important role. There was a trademark case again. So the plaintiff witness affirmed to the fact that it was not his own trademark but a trademark of a certain other entity from which he got assigned. But there's a law in trademark which says that if there is an assignment, it has to be in a written format. So then I asked him whether that assignment is in a written format. He said no. So therefore his rights over the trademark ended then and there, since he was not the originator of a certain trademark. So that is why cross examination is very important in these cases. So then thereafter, when this examination is done, and then of course the stage of final arguments come, wherein the whole the recordal of the evidence is given to the judge, the documents which were produced, which were given to the judge, and the arguments are produced before the judge, giving out or listing out our grounds, and the defendants will list out their defense, saying that no, I have a right over this trademark, or whatever the defenses would be. And then the judgments come, the judgment arrives, and in whosoever favor it is, the damages are given to the opposite side. If it is in favor of the defendant, no damages per se, but litigation costs are awarded to the defendant. Now, why these are awarded? Since the case has been decided against the plaintiff, so why would a defendant suffer from all these damages? There should be an award of litigation costs in favor of the defendant, so that whatever time and whatever money they have given for this litigation, it should be given back to the defendant, since this was a frivolous case, or even otherwise this case was not in the favor of the plaintiff. So that is how the whole proceeding I have covered in a very concise manner of an IP suit comes. But obviously it is much more than this. There are hundreds of applications which are filed, hundreds of non-compliance applications, hundreds of contempt applications after the injunction order, saying that, see, the court gave an injunction order against them, still then they are now using the trademark for which they were specifically restrained to do. So therefore a contempt application is then filed under order 39 rule 2A. So this was 1 and 2, that is the contempt is filed under rule 2A. So rather a very hectic process of the whole IP area. And my last topic for today is grey area of IP laws. So the grey areas comes under wherein the statutory rights collide between two IP rights. Let's say, for example, there is a trademark and there is a copyright. I have a question for you guys. Let's say you all would have seen that Parle-G packaging, right? So there's that small kid which is mentioned, which is portrayed there. So that particular kid which is portrayed there, is it a trademark subject matter, or is it a copyright subject matter? Anyone? Copyright. And why copyright? Good. So yeah, it is an artistic work. But a gray area comes since it is being used with the goods and services, it can also be trademarks. So this is a major gray area in the trademarks and copyrights. Now, when you apply for a copyright, you say that now copyright which is to be used in relation to goods and services. Now let's take example of this whole packaging of Parle Ji. You apply for a copyright, you say that this is my artistic work which is to be used in relation to goods and services. Now what would the copyright registry say? Copyright registry would say that now go to the trademarks department, get a search certificate letter, and then apply for a copyright since your copyright is being used with goods and services. Now what would this person do? The applicant would do? The applicant would go to the trademark registry, would then apply for a search certificate. Search certificate would include that, see, the that search certificate is given from the trademark registry, and it is written specifically that we have conducted a thorough search on this trademark, on this particular artistic work, and we have found no similar artistic work in relation to this particular artistic work, and no similar trademark in relation to this particular artistic work. So therefore it can move out to copyright registration, and with that certificate I go to the copyright registry and say that, see, I have gained this trademark certificate, now give me a copyright registration of this artistic work as well. So this is how a gray area is covered. But in litigation aspect, what would happen if this gray area is actually put up in a litigation aspect? Now, if someone files a trademark or say a copyright, I guess I'm taking a lot more time. So just the last thing, this gray area. So yeah, when sorry, I forgot. The trademarks are compared into from three categories, whether they are conceptually similar, whether they are phonetically similar, or whether they are visually similar. Visually similar is you can easily understand that Gudiya of Parle Ji is similar in Gudiya of Parle F, let's say. So that is how visually similar. Now what would be phonetically similar? Parle G is very much phonetically similar to Parle JEE. Parle G. So that is how phonetically similar trademarks. Now when I apply for a copyright of the Parle JEE, the trademarks registry, what they'll do is they'll just see the visual aspect. They'll not see the phonetic aspect, they'll just see the visual aspect, and then they'll say that since this is being applied for a copyright, it has nothing to do with the phonetic aspect. So therefore the artistic work of Parle G can be easily registered under the copyright registry. Now a client comes to me and says that, yeah, see, he's using Parle G, there's no difference in my Parle G and Parle JEE. So I'll put up in a situation where that since he has a copyright registration and my client has a trademark registration, now what would I do? Now courts have never assessed this criteria, but since the common law allows the law of passing off, the courts would definitely, since it has not been held anywhere till now, the courts would definitely give in favor of the Parle G, saying that his copyright registration needs to be cancelled because of the phonetic similarity, because since Parle JEE would also be used in relation to goods and services, it would hamper the goodwill of Parle G, and it would misrepresent his goods as the goods of original Parle G goods. So therefore this copyright has to be deleted from the copyright registry. So that is where the gray areas of IP laws come. I would have covered 2-3 more gray areas if I had more time, but as for now this is much. Thank you.
Thank you, Mr. Kang, for your wonderful session. We learned about initiation of litigation, types of actions in IP suit, possible claims, injunctions, types and classes. And now, I would like to request Shivanshu sir to please come on stage and present a shawl and memento.
And just to mention, I'm not doctor.
आदि है ना उसके लिए.
Thank you, sir. That was a very wonderful session. Now let's move ahead and discuss why should we file patent and what are the benefits of patent. Having a patent provides legal protection for inventions, encouraging innovation by granting exclusive rights to inventors. This protection incentivizes investment in research and development, fosters technological advancement, and promotes economic growth. In industries, patents are crucial for safeguarding proprietary technologies, attracting investors, and gaining a competitive edge in the market. Overall, patents play a vital role in driving innovation, protecting intellectual property, and stimulating industrial progress. To get more idea about the benefits of patent, I would like to introduce Mr. Neeraj Saxena.
Mr. Neeraj Saxena is the Chief Manager at Avionics Division HAL Korba with over 25 years of experience in Hindustan Aeronautics Limited. He has a specialization in avionics systems for Jaguars and Su-30 fighter aircrafts, particularly in production and control. From 2016 to 2023, Mr. Neeraj served as Nodal Officer for IPR activities at HAL, managing patent application filings and training sessions on IPR awareness internally, and for MSME industries, he received IPR training at RJNIIPM Nagpur. So please give a round of applause for Mr. Neeraj Saxena.
Thank you. Respected faculties of RGIPT, dignitaries from other institutions, participants, ladies and gentlemen, good afternoon to all of you. First of all, thank you very much to RGIPT for giving me this opportunity to share my little knowledge and experience on how I have managed the patent applications, all IPR applications at HAL Korva as a responsibility given my division, not towards additional work, the working. And because till now I have interacted with MSME vendors and even CSIO lab, DRDO labs regarding this patent kind of things. I'm feeling very honored and thrilled to be with you sharing this experience because I feel I will also learn. It's an elite class of scholars present here. So I'll also feeling very honored. As I have been told that I have managed some applications there, but managing applications at HAL, it's a little different. So I'll be sharing all these things with you. And background of topic, the benefit of patent, it's very interesting because unless there is a benefit, what will motivate you to go for some innovation and doing this, filing the patent and going through this such a cumbersome process, which my earlier speaker and next speakers will be telling because they all are from law background. So it's very cumbersome procedure, filing fees, going to some office, and if really it's not doing any benefit to you. So I'll be going by different means showing you the benefits of patents and how it is related to the industry. What is the importance of these patents in the industry? Because most of you will be joining the industry later on, and I don't know, some of you might be in industry already. So I'll start with that, and I have a request that let it be an interactive session. You can interrupt me anywhere, and you can give your views also. I'll be happy to listen your views also on that because it's not legal kind of thing. Only I'm giving certain statistics and certain general things I'll be discussing with you on this topic. So please feel free to interrupt me anytime, and give your views also anywhere. Now, this you might be reading from the morning, but I'll just go through to begin my words. Now, IP means a creative idea and expression of the human mind intellect that have commercial value. So benefit starts from the definition itself. It has a commercial value, and no, we have to earn money. Industry is a commercial organization, so it starts with the definition itself. Benefit is the commercial, and it's a property. You can sell it, you can buy it, you can license it, you can get lease. No, your royalty will be coming in the subsequent slides. So it's a property. Any property, you have a land, you have a gold, you have, no, so you have a patent, you have IP. So it's a property. This also I will go through quickly because I have to just show you where the patent lies in this categorization. So in the last, you can see patent, it's a industrial property. Okay, so the word property itself gives you a feel that it has a benefit, it has a commercial benefit for you to grow and expand. And this also you might have seen since morning, the patentability criteria. Definitely a patent shall be novel, something new should be there. Some inventive step has to be there, otherwise it will fall. And above all, it should have an industrial applicability. In subsequent slide it will come that why it has to be there. You can feel when it's a new idea, it should be patented. So why it is not patented unless it has an industrial applicability, you'll come to know. And that is a main baseline that what is the benefit of the patents. It starts from here. Before we proceed, that what is the benefit of patents, what is the significance, why we need to have the patent filed. For an organization like RGIPT or any other research organization, it avoids a duplication of research. Now something has been already done, so why you should do it again? You will waste your efforts, your mind, your knowledge, your resource. If some lab is doing it, so they unnecessarily will do it. So something research has been done, something has been developed, which is of use. It has been patented, so it is available. So please do not do it again. For institutions, it serves as an indicator of achievements. How much patent? Nowadays it's in our culture now. Earlier it may not have been there, but now it's really in the culture that how many patents you have filed. You see the IITs, you see the DRDO labs, you see any other organizations, universities. No, they are behind it. They are giving, even I think in NIRF rating also of the institutions, it's one of the parameters. I'm not sure, but I think it is there that how many patents you have filed, or I think IPR. So it's a file. It's a indicator of your achievement. It increases the improvement of existing technology. You had earlier the keyboard mobile phones. So someone got motivated. This keyboard is very difficult. Press something that so something was done on the touch screen mobile. So it's an advancement of technology was done. You say in other way that because the keyboard mobile was developed, so something was thought on that some advancement is to be done. And many more advancement. I'm giving you just one example, the touch screen mobile came. So it's an advancement. So you get encouraged for that. If something has done, okay, let me do something more advanced on it. It keeps you abreast, what is going on in world, latest in the, you might be in some other, some is mechanical engineer, some might be in pharma. So in your own field and especially in your area of interest, you can keep yourself updated that what has been the latest development of technology in this field going on. And all the published patent, every Friday there is a journal, Indian Patent, Controller of Patent publishes, and you can get what has been published of your area of interest. It's an ocean of scientific knowledge, especially for the engineers, the doctors, whosoever are related with the science and technology. Definitely patent is an ocean for them. once it is patented, it is commercially exploited without fear. Otherwise, the friends like Dr. Samrats are here to help us. So without imitation, you can do it. You basically get a right for legal proceeding against any infringement if you have really got patented. If you are in an industry, with each research or each product you develop new, you increase your market share, you venture in a new markets, because it's a new product, so something which your company has to attract the consumers. It increases the valuation of your company because you come up always with some new product or new technology in that product or new feature in that product. So it gives you a lot of profit because you put your invention in practice, so you get more profit and more sale. And even if you are an individual, you are not in an industry, you earn royalty. You do something in your lab, you give it to some industry and say, okay, I will not be part of your industry, but I'll be selling you this. So you can license it, you can transfer the technology to industry, and you can keep on earning the royalty for that invention which you have done as an individual also. See, this is just how they are related. Commercially exploitation of patent with the R&D. Even as an individual, I'm insisting on it, even as an individual you can do it, nothing stops you. So you do some research, you come up with some idea which is which has industrially applicable, some importance. You create patent, then you go to the patent office, you get your patent protected, then you can go to you join hand with some industry, or if you are in industry, give to them the production people and the maintainable people. So they commercialize it, you earn money, and then again you can put that money for further invention. You can come up with further advancement of the technology or with a new feature of the product or new product itself. See, IPR, or for that matter patent, it's not just a legal instrument. That's what I was telling you in the previous slides also. It represents a commercial value. Like you buy a share, you buy a HL share, you get a paper out of some money. That paper is really a money. So it's a commercial value. That paper which you get from the controller of patent, it has a commercial value. Thus, it can be a financial instrument. Now it's up to you. How do you exploit that instrument? You want to license it, or the technology for some given right. So what exactly you get when you get patented? So that you can understand what benefit you get. It's exclusive privilege, the right which government grants you. Okay, it's legal right you get to the patentee, whether you are a natural person or you are a small entity or a big company like HAL, for the 20 year of date of filing or priority for commercial gain. So you will not be doing any research for the fun. You will definitely looking for getting some commercial gain from it. And it's a territorial right. For wherever you file it, you get the right to the territory of that nation. See, if we say, I said in a different words, it provide you the patent, provide you the necessary protection in today's to grow and expand. I'll be giving you several examples why people are running behind patents. Now, why there is a race to get more and more patent to survive in this economic world, in this industry. Because patents, it keeps the credit, your credit is due. See, for benefits, let's go by one. What it gives to the nation? The GDP. I'll showing you one of the slide that how the GDP is dependent on our innovation. Innovation means again same thing. It's complementary. You get patents because new product comes, the new market grows, market expands, the GDP grows. The employment, more and more industry. grows, bigger industries more for their production after their innovation, like Apple and other big things, big companies, they gives more employment and the strategic importance. Like we are doing working for the defense, DRDO labs, CSIR labs. So we do many research, DRDO do many research. So it's very important for the nation point of view. So this is one corner that what patent gives to the nation. You see from the consumer point of view, it provides a very new product or a new service. So any common man who does not know anything about the patent, so of that, you drive, it's a drive solution to many of the society's problems or important needs. Like I gave an example of this touch screen mobile. There was no problem as such. Keyboard, mobile was working fine. But okay, something felt, something more, so more convenient came. So some of the long, sometimes it is someone feels need, and sometimes some feels switch on the television. So that laziness gave an idea. Okay, let's have a remote to switch on the television. So such a silly way, to innovate something and get and commercial gain from that. This helps protect consumer from inferior or dangerous counterfeits, because patents are protected. So the company which gives the product, which launches the product, want to make money. So they don't want. They helps you to know that you don't get the counterfeit products. From scholars, so innovation is promoted. Like RGIPT workshop just help. So I am very sure you, because you have already learned much about the patent. So it will definitely motivate you to find out something new, some innovative things. So once some innovation comes, and after that advancement comes, so it promotes. I was telling you, because once you commercialize something, some of your innovations, you get money, so you get motivated. So part of that money, you again put back to your innovation. It helps industry to realize and monetize and secure, because your innovation, you have a patent, and Apple has many patents, so Apple is surviving on that only. They are growing on that features only. So they grow up market value and develop your markets. From industry point of view, it has been observed that company who are IPR system based growth, they do better. Those companies who respect and who have the hunger of this having patents and IPR, they do much more, because they have a higher market value. They have they help small and medium industries, because the production and small things they outsource to their small companies. So the small companies also get the business every time the new product or new feature comes in that product. So industries which rely on reports, it has been reported that they earn higher growth and their revenue is higher, those who rely on the patent and IPR. See, this one figure I had seen many where, so I thought that I should share with you also. It's a very good message. The goddess of knowledge, the academy, the research labs, and the scholars, elite scholars like you, and the how they are related to each other. The goddess of knowledge, the part of that, if transferred to the industry can really make money from that, and again the part of that money can go back to the research institutions and can motivate scholars like you or the institutions like RGIPT to again promote innovation. So as a scholar or as an individual or as an institution, RGIPT or any other institution, what they can do? No, it's not rocket science. Our scientists or the faculty or even the students, no, they all can be the inventor. A very simple approach is required to become an inventor. It's not very difficult, and I'll be telling you also in a very simple language. You just identify some problem. When you are identifying the problem, don't consider that problem is big or small or technical or non-technical or commercial, what kind of problem. You identify some problem anywhere in the society or anywhere around you, and you have to solve that problem by some product or some process. The moment it is solved, you just have to apply it. Put up it on a paper, apply it with a procedure you might be aware, and the moment you get the patent, you can avail the commercial gain from that. See, some of the areas for you, it's not the limit. Just some areas, I'm just giving you just to open up your mind. It's a global goals for the society. Global goals. These goals, you go to any of the goal as per your interest, as per your knowledge, or as per the stream where you are studying something, hunger, you name it, energy. You see anything, you protect the planet, life underwater. Wherever you feel, wherever you have knowledge, wherever you have no resource, you find that area, you will find not many problems there, and you can find small, simple solutions. My subsequent slide will show that how simplest solution has changed the world. So this is just a limit for a representation purpose, that how you can be a part in solving the global problems. Coming next, what is the importance of these patents in the industry? If you see this slide, just to appreciate that if a patent system supported economy is there, how it grows. It's for the US, and from 1850 they were nothing, and if you say 2010, they had around 3 million patent in their kitty, and you see the economy, they are growing. So this must not only surprise you, but you can appreciate that how patents are important in the industry in this economic world. 38% of US GDP is on IP based, which has 80% of the market value. It's the statistics I have taken from the WIPO, World Intellectual Property Organization, so you can trust them. Another appreciation, if you see Fortune 500 companies, 70% of their value comes from their IP only. That means only 30% of those big companies where you want to be the part comes from the regular things or patent which had expired 20 years back. But 70%, if you really want to grow, you really want to expand in this economic world, in this industry, then you have to be innovative. You have to come up every time with a new product, new feature. Apple launches an iPhone almost every year. None of the phone have the repeated features. Every time they add something new which attracts you, and for that you spend lakhs. Some examples, just for your appreciation, that you understand that it's not rocket science, or you need not to be a big, resourceful to do something. This spin brush, even I have seen this spin brush, nothing. And definitely it's my personal opinion that some lazy person might have invented it. So 4 inventors sold it to Procter & Gamble for 475 million. So a small spinning kind of thing which normally people are doing by hand, and I don't think that it serves some additional purpose except doing by hand, but spinning, it looks very attractive for the children. So they earn money. These four inventors earned good amount of money. Paperclip. Can you imagine, it was invented in some 1900 by John Weller. And till now, so much advancement in such a small thing has happened. 400 patents are there in paperclip. 400. So, no, again, it's my personal opinion. I sometimes feel that you even need not to be educated to do some invention. No, we do jugaad jugaad is very popular word in our country. But from technical or legal point of view, if you see, every jugaad is an invention. Every jugaad you do, it gives you some commercial benefit. Either it is cheaper or it is better. If it is cheaper or it is better, then definitely it is patentable. Chotu Cool. This is very good example. And Godrej invented it. Because we have a long geography and our conditions of our country is very different. So our products does not have accessibility to the cooling stations so easily. Like US has some 80% and even China has better. US is 92%. We have only 20% because only urban area have good electricity and can have the refrigeration. So how do you sell the chocolates or the ice cream in a rural area kind of things? Chotu Cool is a good option. He removed all this refrigeration part and put some computer controlled. I don't know much detail of that, but I got very fascinated by this research, so I thought that I will share it with you. That how it is benefit to the society. Some of the example I will go very quickly because they are little funny. It solved some problem. Not that it did not solve any problem. It is patented. Adhesive tape. You cannot say. It definitely solved some problem. It's patented item. You had earlier ink pen. You might have not had, but when we were in childhood, till 10th I think I used the nib pen, and very difficult because nib used to break, ink used to spread. So ball pen was the solution. See, this I wanted to show you for different purpose. This Coca-Cola bottle, it's a saying about this Coca-Cola bottle. If it breaks or any single particle, you cannot copy, you cannot infringe. Everything of that Coca-Cola bottle is protected. Everything. The design, some has copyright, something has patent, some has industrial design, some has trade secret. Nothing of that bottle you can copy. So you can have that also. Benefit and the commercial uses, and importance to the industry. It's the cheapest car of the world, $2,000. And you will not believe that it has 31 design and 37 technological patents. I'm not sure it is Tata Nano or something else, but it is. This you can interpret in your own way. This one example, although my earlier speaker had spoken much about the infringement, but I'll tell you why industries fight each other on patent, because it definitely affects their revenue, their profits. So, just one example to appreciate that industries are really in hunger, in protection of their patent, because it affects their revenue. Entire business is affected when something get stolen or something get copied. So mechanical people can understand it a little better. that Bajaj developed a technology, dual twin spark ignition technology. Now, and TVS copied it. Bajaj claimed something like that, that TVS copied it and they named it controlled combustion variable timing intelligent technology. So Bajaj got this technology patented. They mentioned everything that this bore, this twin spark, this size, and it has benefit in mileage, something of that sort. They use in many of their vehicle somewhere around 1995 and some after that, because they got it patented in 2002. So after that they use. And they says that TVS has launched their vehicle Flame in 2007 and they have the same technology, twin spark plug configuration technology, which they said, no, we have variable time or something of that sort. And these two companies had a long legal battle, almost 10 years, and finally, because they compromised each other. Why they were fighting each other so desperately? Because it affects their business. Bajaj increased their sales multifold, popularizing that technology which they claim that TVS has infringed. So finally they settled it, and because they were, finally they both thought that it will not be fruitful for them. So they had a compromise. Even it's a long proceeding, it's a case differently. I just took first and last slide of that, just to appreciate that that it affects their benefit. So there is an industrial importance of patent. No one want to lose it. No one want to lose their business. So they had almost a decade fight in the courts. And at one point of time, TVS was asked to make records of all their profits, that if Bajaj wins the case, they'll take all their profit back. Now, before proceeding, because I'll be going showing you certain statistics after that, certain interesting facts. These are on a very little lighter note, that we understand that patents are granted normally in 5 to 6 years after filing. But I tell you, things are changing a lot now. As per my information, which I got from RGIPM Nagpur, that even in 7 to 8 months, they are granting the patents. So procedure is not as cumbersome as earlier it was. Now we understand earlier it was very cumbersome. Now we had manual filing, then examination, then responding, hearing used to be very difficult, then appellate board, but now it's not like that. Now you want early publication, you can do that. Examination are done much faster way, then you can respond it very quickly, the hearing comes. So no, it's not like that now, but it's saying 80 to 85% of inventory of granted patents remains ideal with no commercialization. So that is also a fact, but it has many other reasons also, because market need is not there. Like I give you an example, after basics phone and before the mobile phone comes, there was a technology, the pager technology. You might have heard in the books, because I used it when I was around 25-year-old. So pager technology got obsolete immediately, because very after that this mobile technology came. So you cannot help it. Technological advancement sometimes grows so fast that in between thing, pager thing, you can search in the Google that what technology it was. It went off from the market very quickly. I think in 2-3 years it went off. But it cannot be blamed. You cannot stop inventing by this reason. But yes, it's a fact. For many other reasons, for market reasons or for policy reasons, many industries are not able to exploit their patents. And for a motivational kind of things, only 8% of granted patents generate 90% of total revenue worldwide. If you include another 92%, you can imagine where the industry will go if really all patents are exploited. And last 2 points are not to demotivate you, it's just to cautious you that take help of other people, because almost 60% of patent applications fail to meet the patentability criteria. I tell you, even we at HAL, we have almost filed 2,500 applications, and we have been granted only 980s. HAL as a whole has 980 IPR. Out of 980, 300, more than 300 are patent, and other are trademark and design and many other things. And even in my division, we have almost filed more than 275 applications, but only 37 have been granted. So, in spite of all cautious, everything, so they get rejected. In spite of that, there is a loud and clear criteria has been given in Patent Act at Section 3 that what cannot be patented. And in spite of that, if you see that your innovation is novel, inventive, everything is there, and then you have, it's really patentable, 30% applications get rejected due to poor drafting. You have done something else, but when as an inventor you are putting it on a paper, you have really written something else. Okay. And even if you read your text after some time, you will feel that, okay, I really have miscommunicated. What exactly feature I have added to that technology or the product is really not coming out. So how you expect controller of patent to understand that? So patent drafting is really a skill. I think you had a session on patent drafting also. So that is really very important if you really want to take benefit from your invention, from your effort. I'll show you some of the statistics why no, we should run behind patents, we should be doing innovation. 5 countries in the world, top 5 countries, they contribute 85% of the patent. Only 5 countries. And I think in PCT, how many? 157 countries are there, I think, sir? No, 157. In spite of 157 countries, only 5 countries, this China, US, Japan, Korea, and Europe. The CPO is Europe, so they contribute 85%. So we are still much behind. Being such a large economy, we are still nowhere. So it's a big motivation for you. So you have a long way to go. If you see this figure by numbers, almost 3.5 million applications have been filed, and India is, I think, some 70,000, some 77,000 India is. But one good thing you can notice here and feel pride as a nation. If you see the growth which is written in the bracket, you will be surprised to see that India has grown 25% from 21 to 2022. So it's a matter of pride, and it's all because of you people, the elite class of scholars, scientists, good institutions like RGIPT, DRDO labs, CSIR labs, and trust from the government of India. We should not forget that also, because then only we can have such kind of statistics. And this regarding PCT is still, at least in there you had somewhere in India, here you do not have India itself. When you companies are filing patent application through PCT, you must be aware to file the patent in other country. If you go PCT way, it's easier way, otherwise you have to file individually in each country. That would be a little difficult. Some examples I'll share with you. There's a statistics from WIPO. Samsung in 2022 claims the #1 spot, and can you believe 6,248 patents they got in 1 year. 6,000 patents. We strive for each patent, each single patent, and this single company has got. Why? Because their R&D expenditure is too high. Almost 8% of their sale, not profit, please see, they spend on R&D. And you can again feel pride by knowing that Samsung company, they have almost some 15 R&D centers across countries, and after Korea, the R&D center at Bangalore is the biggest. And I do not have the number here, but Bangalore gives them maximum numbers from that. So we have the talent. Only thing is that our talent is not channelized. So that's why the need of these kind of workshops and calling so many speakers and educating you, making you aware that what you can achieve. Areas you know better than me that where Samsung is. Now IBM earlier was its number one, it slipped to number two, and IBM is considered as a big blue in US for receiving the number of patents every year. Last year they received some 4,300, and in terms of cumulative, how many, which I showed initially that 3 million patent US had, they have almost 43,000 total active patents I'm talking about, which they are making money. 43,000 patents they have in their kitty. So you imagine this kind of industry, how much revenue this company would have been generating across world. Key area you know again better than me because you are in college. Taiwan semiconductor. Entire world is revolving around electronics and computation, computers, IT industry. This company, which holds almost 55% of the world market, you see they are growing and expanding just because of they have patent system based growth. They are relying on the patents. You see the second line, 42% growth they had from the previous year in the sales because of those patents only. So they need the scholars, they need the scientists, they want something new to be done, and they can put money, they can earn money, and they could again put back money for the research. After these three, we can go very quickly. Hawaii is the fourth place, 2,800 patents, information and communication technology. And very interesting fact about this company, half of their manpower works on R&D only. Because I was telling you, these big companies who do spend much money on innovation, they really offload their production and non-productive kind of, non-core kind of things to smaller companies. So with the invention of these big companies, even smaller companies, very small companies also, they get benefited. Canon, again, and Canon, you see 73,000, more than 73,000 active patents they have. And they are the company who are continuously in top 5 in getting the patents. So you imagine that how much they are concerned, they are they hard work on getting the patents. LG Electronics, 2,600. Hardly any house is there where any one of the LG product might have not been there. Qualcomm, 22% growth, 2,000 patents. Intel, 2,400 patents. Apple, 2,200 patents. So this just to give you an idea that how industries are growing and expanding and why they are so big. So they are so big because of these patent-based growth system only. And patent means some new things which only the new idea can give. How it is in India? So actually I wanted to take you, this journey, that where the world is and where we are as a nation. So it gives you a gap. How much we can do, how much we have to do still to bring India to that level. You see, still, this is a 5-year data actually. Still, if you see, the CSIR leads with a high margin. Even second number is the BHEL, which is a government PSU. Then the companies come. You see the TCS, TVS Motor, Tata Steel, Wipro, ITC, Reliance Industries. So this is the statistics for 5 years, how much patents they got. And just for you to feel happy, even our universities are not behind. Universities are doing very good nowadays in filing the patents. This is a 5-year data. You see the LPU. IITs, if you put all together, they tops it. If you put different separately, then they are different. Even SRM has some 553 patents last 5 years. See, this statistics I have taken from the annual report of Controller of Patents issues every year. Just to see the how, in India also, we are growing. We are now focused on it. We have started understanding that patent is the only good way for industry to grow. So if you see this 2017 to 21-22, we have grown quite long. More than 66,000 applications have been filed. And why I'm showing this examined and granted and disposal also, just to show that even the controller of patent is also working very hard to grant you patent, to dispose of your application fast, so that you don't get motivated. Last 4 years I have filed it, nothing has come. No examination has been done in spite of paying entire fee by me. So they are also doing very good now. And if you want to see how state-wise patent applications are filed, so it's very clear. You know where the industries are, where the good educational institutes are, and how they are filed. It's a statistics released by Controller of Patents last year. See this top 10 applications filed by companies, industry actually, because the importance of industry has to be understood. So this I'm showing just to show that. TVS Motor, CSIR, here the industrial products which CSIR has offloaded to industry, after TOT or the way they want. So you see the companies. But at the same time, if you see top 10 foreign companies, those who have filed their patents in India, so they are also quite big. Means they have developed the product somewhere outside and want to protect their rights within India because they have to sell in India. India is a big market. So companies want to file. Now all together, if you want to see, so you see this Excel sheet. If you see the last 21-22, it will give you very much motivation. If you see the first column, natural person, 12,000 application was filed by the persons like you. Natural person. They did something at their own, with their own resources and filed the application. This is out of some 66,000 which I am showing here, is that it's a good numbers. So lot of efforts are being put by scholars like you. And if you see the industries, a good amount, some 35,000 applications were filed by the industry itself. So because they have to grow. This list I taken, I just cutted it to show where the India lies. It's a index, Global Innovation Index, which is released every year. And for your information, I should tell you that in 2018, India was at 57th number. By collective efforts of the government, educational institutes, scholars, labs, industries, India has reached to the 40th rank. But 40th rank, if you see, very small countries are above us. So it's a time to think for us that we have to do a lot. We have to work in every area of industry or institutions. This clip I took last week itself when I came to know from Dr. Dubey that I have to take a lecture with you here. So just I thought this cutting I'll show you that Ola Electric, races ahead with 2005 EV patents. So you can be part of this journey with not only Ola, with any of the industries. And if I can read, in battery itself, they have some 90, more than 90 patents. So this just to conclude, innovation, if you want a long-term health or long-term wealth in your nation, then you have to put ideas, concepts, the knowledge in the root, and finally you have to get a big tree which gives you fruit. This fruit is innovation. Then only you can grow, you can develop, and you can fulfill your dreams, your nation dreams, and for your society. Okay, that's all is from my side. I was expecting some of you will share your experience also. I'm open. If any of you can give your opinion of any of my experience and learning, which I brought to share with you, I'll be happy to see, to listen from you.
Good evening, sir.
Thank you very much.
So it was a lovely session to be here, sir.
Yeah.
Sir, besides like advantages and disadvantages go hand in hand, besides the innumerable benefits that we learn for having patents, is there any disadvantages, if at all?
Any disadvantage of having
Having
patent?
patents, exactly, if at all.
No, I don't consider. See, I am handling patent for last almost 7-8 years. Till now, I have not understood that there can be any disadvantage of having, of having patent. I cannot even imagine it. Because you are helping society, you are helping your nation, you are helping yourself.